Good day, Doctor. My name is Smita from Pansanmugam. I'm via Firm 19 presenting on the topic of duty of the counsel to be able to appear once brief is accepted. Beginning with the introduction, the relationship between an advocate and solicitor with his client is one of a fiduciary relationship in which the client places his or her confidence, reliance and trust in the advocate and solicitor, whose advice is sought in certain matters. In general, an advocate and solicitor could decide if he or she wants to represent a client and take up the case. But once brief is accepted, the advocate and solicitor must perform the duties towards the client. In the context of Malaysia, neither the Legal Profession Act 1976 nor the Legal Profession Practice and Etiquette Rules 1978 define the term brief or explain on its contents. Thus, seeking the common law practice, for the purpose of this article, brief is plainly regarded as a document often in the form of summary or abstract. In this presentation, my teammates will further explain about the importance of ethics, the history of lawyers' ethics, relationship between lawyers' ethics with jurisprudence, about the relevant rules in the Legal Profession Practice and Etiquette Rules 1978, example of Malaysian cases and example of United Kingdom cases regarding our topic, duty of counsel to be able to appear once brief is accepted. That's all from me. Thank you.
Any profession needs ethics, but in the legal field, where lawyers in particular are viewed with suspicion, it may be even more critical. Thus, maintaining an enforced code of behavior is essential to maintaining the legitimacy of the legal system, practitioners, and overall. Generally, ethics are crucial for addressing fundamental human needs, establishing credibility, bringing people together, fostering leadership, enhancing decision-making, achieving long-term goals, and securing society. If seen from the perspective of legal ethics, the main goals of legal ethics are to protect the honor and dignity of the legal system, ensure the spirit of cordial cooperation, provide the reciprocal and fair treatment of counsel with clients, and ensure the obligations of laws to society. There are some fundamental principles that constitute the essence of legal ethics. These include diligence and dedication, professionalism, uprightness and integrity, personal development, and the impact of technology on professional ethics and the general practice of law. The legal profession has existed for over 2,000 years. Throughout history, from the Greek city-states and the Roman Empire to the present, legal advocates have been essential and active participants in the creation and enforcement of laws. Lawyers are held to unique standards, rules, and liability due to their position in society and their intimate engagement in the administration of the law, sometimes referred to as legal ethics and other times as professional responsibility. The phrase law guiding lawyers may be the most comprehensive way to express the subject. In this part, I have told the history of the existence of legal ethics since the 12th century in England until the Legal Profession Act 1976 was enacted in Malaysia. If this fundamental idea is accepted, it follows that jurisprudence and legal ethics are the complementary sciences and the legal ethicists must address jurisprudential issues when considering the conduct of lawyers. Whatever the reason for this peculiar situation may be, it is obvious that jurisprudence must be discussed before discussing legal ethics.
Article 5, Clause 3 of the Federal Constitution enriches a person's right to be represented by a lawyer. Besides that, Rule 2 of the Legal Profession Practice and Etiquette Rules 1978 also stated that lawyers have a professional obligation to accept instructions from every client, or also known as the cap rank rule. Despite the cap rank rule, under the Legal Profession Act, there are a few exceptions in which an advocate may choose to refuse to accept any brief at their discretion. One of it is Rule 6, in which is stated that do not accept brief if unable to appear without sufficient cause, and where a counsel has accepted a brief, they should be deemed as reasonably certain of being able to appear and represent their client on the required day. Not only that, Rule 24 of the LPPER also stated that there is a duty on the part of the counsels to be ready for the day fixed for trial. Postponement is allowed. Article 5, Clause 3 of the Federal Constitution enriches a person's right to. Next, there are a few main ideas that can be derived from Rule 6 and Rule 24 of the LPPR 1978, in which, firstly, counsels have the utmost right to not accept any brief if it is certain that he will not be able to appear and represent the client on the day fixed. Secondly, once brief is accepted, there is no turning back to simply withdraw from appearing in the courtroom and decline his client's right to be represented by him without any sufficient cause. Thirdly, having accepted the brief, counsels were not entitled to postpone the dates that had been fixed except. Next, there are a few main ideas that.
Next, there are Malaysian case law which supports that counsels are bound with the duty to appear and make every effort to appear once brief is accepted. First and foremost, the landmark case of public prosecutor against Mokhtar bin Abdul Latif. In this case, the counsel for the accused applied successfully for the postponement of the trial 3 times as the counsel claimed to be engaged in other courts. The court referred to Rule 2, 6A and 24 of the Legal Profession, Practice and Etiquette Rules and Section 73, Clause 3 of the Legal Profession Act and held that the counsel had no good or cogent reasons to apply for postponements of the hearing and he should not have accepted this brief or the other brief which clashed with the trial dates. Next, in the case of Tan Sri Dato Deong Hiu King against Lau Si Kwong, the High Court emphasized that the new counsel who replaced the former counsel in that case had to ensure he could obey the court's order. The court further stated that he should not have consented to take over the brief if he cannot comply with the direction given by the court. Further, in the case of Dato Sri Najib against public prosecutor, the appellant applied to adjourn the hearing on the basis that they are not prepared yet. The court referred to Rule 6A, 24A and B of the 1978 rules and stated that where counsel has accepted a brief, he should be deemed as reasonably certain of being able to appear and represent the client on the required day unless cogent reasons are provided.
So one of the case is the Conservator's case. So in this case, an English nobleman was murdered in his sleep. So the case gathered a lot of attention from the public and also the media as the higher class was terrified by the thought of a wealthy man being murdered in his sleep by servants. Conservator was the target of suspicion as there was a solid evidence against him. Charles Phillips, the top criminal defense attorney in England who had a well-deserved reputation, represent him. After a series of examination and cross-examination, the jury found Conservator guilty. The truth had been unveiled after the decision. Conservator had confessed his guilt to Phillips and requested that Phillips continue to represent him. Phillips initially considered withdrawing, but he continued representing Conservator. Phillips persists in aggressively cross-examining the witnesses, despite the fact that he knows his client was guilty. The information that Conservator confessed to Phillips during trial spread quickly. Phillips received a lot of tremendous amount of backlash from the press and his reputation was never restored. The other famous case is the Westerfield case. So in this case, a 7-year-old girl was kidnapped from her house in the middle of the night. The neighbor Westerfield was accused of the crime based on strong circumstantial evidence. Feldman, the defense counsel, stated that there is uncertainty about the girl's cause of death, the killer, and also the person who killed the youngster in his opening statement. Feldman mentioned Daniel's parents' swinger lifestyle and the fact that they host sex parties at their home during his cross-examination of them, implying that a visitor to one of these gatherings may have killed the girl. Feldman was aware that the implication he was attempting to draw was false. However, Westerfield had been found guilty. A resounding protest was heard in the local press, and the San Diego Union Tribune editorial claimed that Feldman was just as despised as Westerfield. The public's disapproval of Feldman's action is uncannily similar to the reaction to Charles Phillips' defense in Conservator's case earlier.
In conclusion, as indicated in Rule 6 of the Legal Profession Practice and Etiquette Rules 1978, a counsel has a duty to appear for his client once brief is accepted. Under the circumstances of being unable to appear, prior notice containing reasonable cause of absence must be issued before absence. Failure to appear in court and trying to ask for postponements of trial gives bad impact to the whole system of justice and tarnishes the good name of the whole legal profession. That's all from us. Thank you.